Hello, friends. We are going to cover Chapter 6, and it is going to be Advanced Directives. So, what we want to talk about first is the difference between just a financial power of attorney and medical advanced directives. A financial power of attorney are legal documents that allow you to basically have an individual make financial decisions on your behalf. A springable durable financial attorney is goes into effect once you become incapacitated. So you would have someone sign this so that they could take over your financial affairs should they or when they become incapacitated. A non-springing actually takes effect immediately upon execution or when you sign the document, and it continues to be effective even once you become incapacitated. A non-durable financial attorney is effective only when you're not disabled or incapacitated. You can make your own decisions, but you need someone to act for you because maybe you're not in the area. A lot of times, a non-durable financial power of attorney is used for military personnel if they need to get business done and they are overseas. You cannot, as the power of attorney, make decisions on their behalf. You can just sign at their direction. So these are financial power of attorneys. Advanced directives all deal with medical decisions. And they give you the opportunity basically to say, hey, this is what I want to happen to me, or this I want this person to make decisions on my behalf. The most common are the durable power of attorney for healthcare, the living will, and the pre-hospital DNR, do not resuscitate directive. So a durable power of attorney basically says, hey, I want to appoint an individual to make medical decisions if I become temporarily or permanently incapacitated due to illness or injury. I'm not able to make those decisions, and I want that person to make those decisions. We refer to the person as your agent, and they can make numerous medical decisions. However, one decision they can't do is to revoke previously existing documents regarding wishes, such as a living will, even your financial power of attorney. So that would have to be done by the principal, is the person who is actually designating the agent. They would have to make those changes themselves. The agent for a durable power of attorney has a right to receive and review medical treatment, or I'm sorry, medical records. But federal law kind of makes it a little bit iffy when it comes to HIPAA. So it's very recommended that someone also complete a HIPAA authorization that designates the personal representative to be able to access any information. Now, a living will is basically saying what type of care you want or don't want at the end of your life if you have a terminal illness. And in Kansas, this is called the Kansas Natural Death Act. It's essentially a guideline for health care providers, family, and close friends. It does not appoint someone to be your voice. You've already made the decision if you want to have a life-sustaining procedures or not, should you be terminally ill. Some of these procedures include ventilator, sustained life for artificial nutrition and hydration, tube feeding, dialysis, antibiotics, or antiviral medications. And they're all things that can be added to a living will that you do or do not want should you become terminally ill. The use of procedures or medication that provide comfort and ease are generally not included in this definition. All states are going to vary on what you can and cannot put in your living will. So these are all directions that you write out and say, this is what I want or don't want. A DNR is a do not resuscitate. That's a little bit different. What that is it says, hey, if there is a need for resuscitation, my heart stops beating or I stop breathing, don't try to resuscitate me. Don't take any effort to do that. And it means that you just don't want medical personnel to um, initiate or attempt CPR. So if you don't have a heartbeat or you're not breathing and you have a DNR, they will not attempt to resuscitate. So there is a lot of controversy um, from what is appropriate, what's not appropriate, but their and states vary what you can and cannot have done or ask someone to do when you're ill and cannot either make decisions yourself or would have life-sustaining uh, proceed or things. The biggest case, maybe you're all familiar with when it comes to the living will, is Terry Schindler Shivo. She's there with her mother in the one picture, and prior to that, she is there, a beautiful, beautiful woman. She collapsed at home in the early hours of February of 1990, and she uh, basically was diagnosed ultimately with hypoxic encephalopathy, and that's a brain injury that results from you not getting enough oxygen to your brain. But she had no advance directive. Okay, so she had nothing to say, do you want me to do everything to sustain life, or do you want to withhold life sustaining procedures? And her husband had actually taken care of her for many years with the mom. I think it was several years, and then kind of moved on a little bit and said, hey, the doctors have now declared her in a persistent vegetative state. He kind of lost hope. So he asked the doctors to have her removed based on wishes he claimed she had before. Her parents did not want her, and her whole family did not want her taken off life support. Her parents visited her quite often and said that she was reactive to them. And so there was this long, decade-long legal battle with her parents, and it went all the way to the United States Supreme Court. And basically they said that the husband, as the husband, should have the right to have her feeding tube removed. And so he did. It's very, very difficult case. It's just traumatic to hear the parents talk about how they wanted to keep her alive. Now, there's debate on both sides, right? Where the parents being a little bit selfish because, they just didn't want to let go. I mean, there's a lot of emotion, and that's the thing, the importance of a living will is so you can make that decision. And then they just have to go with your wishes and say this is what they would want, right? So she did die about 2 weeks after the tube was removed, and it seemed like it was pretty difficult to watch from her parents' perspective. So, kind of hand in hand with this is whether or not you can withhold medical treatment. But how about getting medical treatment to help you die at the end? And that's called death with dignity, is what they call it. And there are a handful of states that do have it, and there are many states where there's nothing pending. Some are considering it. So it's very, very controversial because basically you're giving yourself a pill, you're giving yourself you're putting yourself basically to death when you get to the point where you can't bear your pain anymore. But it's an extensive process you have to go through before you can even be approved. Oregon has it, and their criteria is adults 18 or older. They have to be terminally ill with a prognosis of 6 months or less to live. They have to be mentally capable of making an informed healthcare decision. In fact, I think they have to go talk to counselors and things like that, psychologists, to make sure that they're not doing it because they're depressed, that they're really making that decision because they want to end their life the way they want to and not being pain. I'm going to post a couple videos after this of some really, really fascinating stories, a couple fascinating stories on this. I really encourage you to take the time to watch them. But anyway, so Kansas proposed a bill that was basically, they modeled it after Oregon. Unfortunately, it was introduced in 2021 of February. At the same time, it went to a committee, and not last year, but in 2022, it actually died in committee, which seems a little a choice of word, but that's what they say. It's not me. It died in committee. So right now, Kansas does not have a proposed bill before it for death with dignity. So the questions I want you to look into are using the Kansas annotated or the Kansas statutes. Remember, go to Reviser of Statutes. I'm going to even give you the chapters and articles for the questions. You're going to look up, for example, the first 4 questions have to do with medical power of attorney, durable power of attorney for healthcare. And so I want you to go through and answer those questions. I have also attached a Word document that you can put those in, but that Word document does not contain which chapter and article it is, so you might want to jot these down so you have them when you're going over the assignment. The next one has to do with do not resuscitate, DNRs, and that's in chapter 65 and article 49. You'll just have to kind of scroll through to find which statute's relevant. And then the last is to do with the Natural Death Act. And this is going to be found in chapter 65, article 28. You're going to want to page down on article 28 to get towards the bottom, and you're going to be looking for the Natural Death Act title, and you'll be able to find it there. So if you answer these questions and then just attach it to the assignment. If you have any questions for me, please let me know.